I'm Sylvia. Thanks for joining me again on Handy Law. We will continue with the series on our fundamental human rights, provided by the 1999 Constitution of the Federal Republic of Nigeria. Today we will conclude Section 36, the right to fair hearing, but this time in respect of criminal offenses. The Constitution says that anyone charged with a criminal offense is entitled to fair hearing in public by a court or tribunal within a reasonable time unless the charge is dropped. However, the matter may be heard privately if the court or tribunal is satisfied at the request of a federal minister or a commissioner of state that it is not in the public interest to disclose the issues addressed in the proceeding. If charged with a criminal offense, you are not automatically guilty. The law says that you're presumed innocent until proved guilty. So what are your rights as an accused person? The first one is that you must be given the details of the offense immediately in a language you understand and be given time to prepare your defense. Secondly, you can defend yourself personally, or better still, get a lawyer to defend you. I will advise you get a lawyer to defend you. You can call witnesses to boost your defense and also question the witnesses called by the prosecution. If you do not understand the language of the court will assign you an interpreter free of charge. You don't have to give evidence at your own trial. This means that you do not have to step into the witness box to be questioned by either your lawyer or the prosecution. You cannot be tried 2 times for an offense except at the order of a superior court. If you've been pardoned for a criminal offense, you cannot be tried again for it. The following provisions are especially interesting to me, for it tells me that the authors of the Constitution must have taken our history into consideration before adding them. The first one says that no one shall be guilty of a criminal offense for an act that was not a crime when it took place. Secondly, no penalty shall be imposed that is heavier than the penalty in force at the time the crime was committed. This means that the laws are not meant to be retroactive. Some of us will recall that in 1985, 3 men were executed for drug trafficking. At the time they committed the crime, death was not the penalty for drug trafficking. But the government at the time passed a law and made it retroactive, so they were sent to death by firing squad. Finally, no one shall be convicted of a criminal offense unless the offense is defined and the penalty is prescribed in a written law of the land, whether it is federal or state laws. In other words, don't make it up as you go along. We've come to the end of today's segment. If you found it helpful, leave a comment. Also, please like, subscribe, and share.